If you have any questions during the session, feel free to type them in the Q&A function, and we will address them later in our Q&A section. Now, warm welcome once again to today's webinar. It is proudly brought to you by EduTech in partnership with Bird Bird ATMD. So I'm Jason from EduTech, and I'll be your MC for this session. So we're just covering some housekeeping. This session will be recorded for archival and marketing purposes. EduTech may use portions for this recording session across its platforms and marketing channels. Now, if you have any questions for our speaker, once again, please use the chat function or the Q&A function. Include your name and company, as this may help with necessary follow-ups as well. Thank you. And again, without further ado, it's my pleasure to introduce to you Ms. O Pin Ping. Pin Ping is an intellectual property lawyer and a partner at the international law firm Bird Bird. With extensive experience advising on the legal challenges of AI and Gen AI, Pin Ping is thrilled to share her insights with EduTech members today. Pin Ping, over to you, please.
Thank you, Jason. Hi, good morning, everybody. Thanks for joining us today. I think we have quite a lot of content to cover today, so I'll just dive right in. The topic that we're talking about today is, of course, AI. So maybe we'll start with a definition of AI. So AI is just a term for technologies that try to mimic human cognitive functions. So AI has been around for decades, but then but has become a hot topic only in the last 2 years. The question is why now? Well, it's largely because of the advent of generative AI tools, which are able to generate content. So that's created a lot of excitement, but also because of 2 other developments. One is an increase in the availability of data. And then the second is the lower storage and processing costs. And this has led to more companies developing and offering useful AI tools, which has in turn led to an increased uptake. So AI is touted as like being able to do things better, faster, cheaper, right? So like some example use cases will be what you see here, but the challenges will be with navigating the risks and legal liabilities that can arise. And we hope that this session will be a good primer to get you started thinking about some of these issues. We may not have all the answers at this stage, but it's good to be at least be aware of the potential pitfalls. So to set the stage even further, here's a visual representation of the technology and the AI ecosystem. So an AI system, like any software, will generate an input given a certain output. Okay, so this is like the normal software that we're familiar with. But the unique feature of AI is that it's built on data analysis. So that the data that is used to train the software model underlying the AI system is very important. How good the AI system is will, to a large extent, depend on the quality of the training data. Right, so what you see here is that you have training data that is used to train the software model, then the software model powers the AI system. Another unique feature about AI is that sometimes user inputs will also be added to the pool of training data so that the AI system will continually learn and improve. So if we want to look at an example of inputs and training data that will be used with generative AI system to get a certain output, I can put in a prompt like a robot artist with an easel painting a landscape of rolling hills, and I want this in a comic book style, right? So now there are now generative AI tools that allow you to create images from textual inputs, right? This will be fed into the system. The system will look through its training data for pictures of robots and hills and easels, and maybe give me something like this. So this picture on the right was generated by AI. The final layer to this diagram is that there are persons that are involved at various stages in the ecosystem, right? So all these people in yellow that you see here. So the problem with there being so many entities is that it can become difficult to decide who is to blame or who should bear the legal liability when things go wrong. And we shall see examples of this in a bit. But before going there, this is the agenda. We'll cover 4 topics today, starting with the things to think about when using AI, right? We will then look at the legal risks and liabilities. In other words, like I said, when things go wrong, who should take the blame or take the fall? The third topic is the debate regarding whether there should be copyright protection for AI-generated works. This will be interesting to those of you who are using generative AI systems to generate content, for example, like your marketing collaterals or stuff to put up on your website. And then finally, a very quick word on legislative developments around the world. So the first topic, key considerations when using AI. There can be many things to think about when considering like, oh, should I start using AI? What tools should I use? And there's a lot of information now on the internet, which can be very confusing. So this is a useful framework of 5 questions that you can use to sort out your thoughts. And we will unpack each of these questions in turn in the next few slides. So the first question is, what is the use case? The use case determines the training data and the inputs that you will be using, and also the expected outputs and what these will be used for, right? So because of this, the use case really impacts the level of legal risk and potential liability. As you can imagine, the risk will be much higher when the AI outputs are not used just internally, but also made available to third parties outside the company. So if your staff is using AI to, say, create an internal mailer to publicize your office Christmas party, then the risks are probably pretty low as compared to if the outputs are external facing, right? In which case, if the outputs are infringe IP or if there is an issue with breach of personal data protection laws, then there's likelihood that these issues would be picked up and surfaced, and you might face potential liability. So additionally, if the AI outputs are used for decision making, then you will have to be more careful to make sure, for example, that the training data that is used and the algorithm is robust and delivers the correct outputs. The second question is, which AI tool will be used? If you're getting an off-the-shelf product, the terms of use are non-negotiable, right? It's more or less a take it or leave it. So if I want to use the consumer version of ChatGPT, the terms are posted on the website and you just have to read them. If you don't agree with them, then you don't use the system. But on the other hand, if you're getting a vendor to develop something bespoke for your company or for your use case, there could be more room to negotiate the terms. So in any case, some key terms that you might want to look out for are set out here. So the first question is, what are the permitted uses of the tool, right? So for AI systems, most of them are, or AI tools, most of them are designed for specific purposes. And the warranties and indemnities that are provided by the developer could be pegged to could be activated only, could apply only if the tool is used for the permitted purposes and void if they are used for non-permitted purposes. So you have to make sure that the permitted users cover your intended use of the tool. Second, where does the training data come from? Does it come from the AI provider or does it come from you, the customer? This ties in with the next question about inputs and outputs, right? So typically the rights to any training data that's provided by the customer and also the inputs and outputs of the AI system will belong to the customer. However, the developer may wish to obtain some rights to use the data and the inputs and outputs for its own purposes. For instance, with the consumer version of ChatGPT, OpenAI is allowed to use the inputs as training data to improve its software models, unless the user opts out. If you subscribe to the enterprise version, then it's the other way around. The default position is that users' inputs will not be used as training data unless the user opts in and tells OpenAI, I allow you to use my inputs as training data. So you have to consider whether you're prepared to accept these terms before using the tool. The final issue is how are risks and liabilities allocated as between the developer and the customer in the terms. So for instance, the consumer version of ChatGPT is very much used at your own risk because OpenAI makes no warranties and caps its own liability at $100. For the enterprise version, there is an indemnity against third-party claims for IP infringement, but this is subject to very broad exclusions. So if you're so on the other hand, so that's for like a off-the-shelf solution. If you're getting a bespoke solution, then there might be more room to negotiate for the AI provider to take on more of the risk. Okay, the next questions are what's in the training data and what inputs will the users enter. So in case it's starting to get confusing, I have replicated here the slide that we've seen before, the diagram we've seen before. So the inputs are what the user will input into the AI system during use, and then training data is what is used to train the underlying software model. So some key risks are, first, any training data and user inputs that are fed to an AI system may ultimately land in the hands of a third party, right? For example, the AI developer. So one key risk is that of leakage of confidential information or trade secrets. For example, like if you have a new product that you don't want to be publicly disclosed, and then your staff unknowingly feeds that into ChatGPT in trying to generate some product description for that. Or simply there might be sensitive information like customer lists that you don't want to be publicly shared. If this is used as training data or AI inputs, then that might be a problem. So one way to avoid leakage of such information is to use a private instance of the AI system so that the information does not need to be uploaded to the cloud or any third-party server. Then, as alluded to before, it's important to ensure that your staff who are using these systems are fully aware of the risks and the consequences. Then the next topic is like data protection laws, right? There is also risk of breaching data protection laws if the training data includes personal data. For instance, when you're trying to personalize marketing campaigns, if your customers and any individuals have not given permission for their personal data to be used for these purposes. So in this regard, the Personal Data Protection Commission has released advisory guidelines on the use of personal data in AI systems. And these guidelines are actually quite useful because they provide a lot of practical guidance as to what you need to look out for. Singapore has generally taken a rather permissive approach. Still, the guidelines emphasize the importance of data minimization, meaning don't use personal data unless it's absolutely necessary, and also using anonymized data where possible. Then finally, with generative AI systems, there are also issues with IP infringement if copyrighted works are included in the training data without permission. Another question to consider is if the developer will obtain any rights to use the training data provided by the customer and any inputs as for its own purposes, for example, to train its own models. As mentioned, the terms of use of some of the off-the-shelf products provide for this. And so if you're not comfortable with that, for example, if the stuff that you put in is sensitive or confidential information that you want to retain for yourself, then you have to watch out for these terms. Then finally, if the training data is provided, still on this point, right? If the training data is provided by the developer, you may also wish to consider if the developer is providing any warranties in relation to the accuracy and completeness of the training data, and that is free of bias. And this is especially important if the AI outputs are going to be used for decision making. So maybe let's drill down a bit more into this issue about bias in the training data. What is the concern with bias? And this is well illustrated by this example. It's quite a funny example of how the New Zealand customs authorities, many years ago, they wanted to have this passport, or rather when people go to the airport, they had this system to try to do facial detection and no, sorry. This is a passport application robot that when people want to apply for passports, they have to upload a picture and then they can get their passport processed. But what happened was the robot kept telling this person of South Korean descent that, oh, we cannot, the photo that you upload does not meet our criteria because your eyes are closed, right? And this is like an example of how they had trained this model on pictures of people of Caucasian descent with very big eyes, and therefore it was not suitable for use with Asian people. And it illustrates how you want to make sure that your training data is free of bias. Otherwise, then things like this will happen. Okay, the final question is about outputs, like what are the outputs and how will they be used, right? So it is well known that there's a possibility of AI spewing out harmful or otherwise inappropriate content. The main countermeasure for these risks is really to ensure that there's a human in the loop to spot any mistakes made by the AI and to take the necessary countermeasures before the AI outputs are sort of like released or used to make any decisions that they are meant to assist. So if you're entering into any contract for the provision of an AI system, you will want to ask who is to be responsible for monitoring the system and whether there are any tools to allow human control and oversight. So if it's like the contract is for the AI developer to develop something and then it passes over to the customer who deploys the same, then the customer is likely to be responsible for doing the monitoring, right? Because the developer is cut out of the picture from the moment the software is developed. But then if you're going for a fully managed solution where the developer is in the picture the whole time, then the developer could be the one to monitor this thing for you. Then the other point about tools to allow human oversight and control, in a contract, you might want to specify that there should be human-machine interface tools to enable the human not only to monitor the AI outputs, but also to be able to intervene and kill the system if need be. Like for example, if it runs amok and goes haywire, as has known to happen. Okay, we look at, well, this is just a funny example of how AI can come up with inappropriate content. Well, actually not so funny because what happened was in 2023, Microsoft's news aggregator AI added the cause of death poll to an article published by Guardian about the death of a young water polo player in Australia. So like the poll was like, oh, guess how this person died. Was it by murder, accident, or suicide? So naturally, many readers were uncomfortable with this, and they scolded Guardian to say, oh, how can you put up something so insensitive? So Guardian swiftly removed the poll. And then there have been reports of Guardian accusing Microsoft of negatively impacting its journalistic reputation. It's unclear how the matter subsequently resolved, but the takeaway is really a reminder to exercise care when you're using AI tools because as Forrest Gump would say, you'll never know what you're going to get from an AI system. Okay, moving on to the next topic about risk and liability. So where does the buck stop when AI goes wrong? So as the old saying goes, to err is human, but in this day and age, to err is no longer only human, it's also possibly machine, right? So the question is, when things go wrong, who should be liable? There has been a lot of discussion on this front, but no clear answer yet. There are really two key issues. And the first is that traditional legal principles governing the allocation of liability were not developed with AI in mind. And there are three features of AI which make the application of these principles to AI difficult. The first is that AI is autonomous, which means that it makes its own decisions, and humans are not fully in control of how an AI works. Second, AI is a black box, which means that it may not be clear how or why the AI came to certain decisions. And thirdly, AI can be adaptive, which means that the software code is not static, right? Like for most software, the software code is like stagnant or it is what it is at the point of delivery from the developer. But for AI, the code could very well change post deployment as more and more training data is fed into it. The second issue or a problem with determining liability when AI goes wrong is that there are many parties involved in producing or providing the AI system, as we have seen from this diagram, all the little people in yellow. So this exacerbates the difficulty of tracing the source of any error and attributing liability to any particular stakeholder in this ecosystem. So when trying to determine liability, these will be the usual suspects, right? So you have the developer who is responsible for designing and coding the system. You have the person providing the training data, and he will be the one to select and verify the accuracy and completeness of the data. You have the person responsible for training. You have the deployer, who is most often the customer. And then you also have the end user, who is the one entering the input prompts to get certain outputs. So, and the other thing to note is that some of these stakeholders could overlap with a single entity taking on more than one of these roles, right? So who should be liable when things go wrong, and how should we decide? And finally, would there be situations when we can simply point fingers at the AI system itself and say that, oh, the machine is the one who did it? So that's exactly what Air Canada tried to do when its chatbot went wrong. So what happened was a passenger lodged a claim for compensation against the airline when the chatbot gave him the wrong information. He was booking a flight back to his hometown for his grandmother's funeral, and the chatbot told him that he could book the flight first and apply for a bereavement discount afterwards. But in fact, that was not permitted, and the request needed to be submitted before the flight. So Air Canada argued that the chatbot was a separate legal entity and thus responsible for its own actions. But this was thrown out by the small claims court, which said that, well, while a chatbot has an interactive component, it is just a part of Air Canada's website, and it should be obvious to Air Canada that it is responsible for all the information on its website. It makes no difference whether the info comes from a static page or a chatbot. So this decision must be correct, as it would otherwise be too easy for companies to shirk responsibility for giving misinformation, especially when the information, again, is on their own channels, their own website or social media platforms. So based on this decision, the buck or the liability stopped with Air Canada. However, like this is not the end of the story, as it is unclear whether Air Canada had gone on to lodge a complaint against, for example, the software vendor who had provided the system. So how can liability arise? There are three main buckets. So legally, you can have liability under tort, contract, or statute, right? Let's look at each of these in turn. So with tort, right, especially the tort of negligence, the issues with legal principles not having been developed with AI in mind become very important, right? In order to prove negligence, there is a need to prove that the person you're saying was negligent had a duty of care, breached that duty. Then, on the other hand, if the person who suffered damage from the negligence had contributed to that damage, then he would be contributorily negligent. But with AI, there may be issues with proving that there has been a breach of any duty of care if the AI's decisions were made autonomously. And the standard of care may also be unclear because really what is the standard if the AI's decisions cannot reasonably be anticipated by human? Then when you get down to causation, right, whether the negligence had in fact caused the harm, it may not be clear if the harm resulted from a defect in the AI software, whether or resulted from the improper use of the AI tool or the general unpredictability of the AI's decision making capabilities. And finally, for contributory negligence, this could be a factor if the deployer failed to monitor the system or the user failed to check the outputs before implementing the same. So so that's the difficulties with negligence. For contract, there could be potential liability under both vendor-facing and customer-facing contracts. And the party which is liable under the contract will largely depend on what the contract says. And this is provided, of course, that the scenario in question had been within the party's contemplation at the time of contracting and had been properly addressed in the contract. So if it's like something went wrong, but then it is not clear who is to be responsible, for example, what we said about monitoring the AI system, right? Then it might be difficult at that point to try to push liability on one party or another. And finally, when we look at statute, liability could arise under various statutes. At the moment, there are no AI-specific laws in most jurisdictions, but then the existing laws, for example, product liability laws, consumer protection laws, IP data protection, will govern the space. Okay, so give me a sec. Let's try to analyze the question of liability by reference to an example. So Olay has an AI-powered product named Skin Advisor, which is available on its website. This uses machine learning tools to analyze selfies to assess customers' age and skin types, and based on which the AI will recommend appropriate products to the customer. So this tool is said to be to have improved conversion rates, meaning like when customers go to shop on Olay's website, the chances that they will buy something are higher, and average basket sizes because customers are able to get personalized recommendations in the privacy of their own homes. But let's imagine hypothetically that Skin Advisor makes the wrong recommendation, and this causes the customer to suffer damage to her skin. So customer is kicking up a ruckus and demands compensation. Who is to blame? Who is the customer to sue? So again, this diagram showing the different stakeholders. Do we know straight off, based on whatever I've said before, which of these entities is to blame? We don't know, right? Because we need further facts to ascertain liability. What if I tell you that it's an error in the software code? Then who is to blame? In this case, it's likely to be the developer, correct? Except that there are adaptive AI systems that can generate their own code in the course of deployment. in that case, then it may not be as clear cut that is the developer that is to blame, or whether it is the person who may have fed additional training data to the AI in the course of deployment. What if there's bias in the training data? For example, the thing we saw about New Zealand passport control. So this could be a problem where the AI's model was trained on a data set that is not representative of the population to which the tool is to be used for. In this case, then liability could fall on the person who was responsible for selecting the data and ensuring it's accurate and complete. So again, these will be terms that you want to put into your contract to make sure that it's clear where the liability falls. Okay, finally, what if there's a failure to monitor the system or its outputs? So AI systems have been known to go haywire in the course of deployment. It runs and then suddenly, I don't know, it just goes mad and gives a lot of like nonsense outputs, right? So in such case, it's likely the deployer that is responsible. But it's not that straightforward because there may be instances where the human is not able to decipher how or why the AI system came to its decision. So there may be little or no basis for the human to second guess and override the AI's recommendations, right? So yeah, so again, what this illustrates is that in any of these situations, the person in the ecosystem that is to blame may not be that clear cut. Okay, and so what can be done to manage the risks, right? First is you want to put in place technical and organizational controls. Um, for example, to yeah, so I think we've already talked about adequate supervision and monitoring of any AI systems being deployed. And then human oversight cannot be overemphasized. And this includes ensuring that your staff who are using AI are adequately trained to be familiar with the limitations of the AI system and are able to detect any abnormalities in the performance of the systems. And when like they detect that something has gone wrong, they must know what to do in a given situation. You want to put in place contractual safeguards. This will be to ensure that the parties' responsibilities are clearly carved up and the risks and liabilities for things going wrong have been thought through and addressed in the contract as far as possible. Then you can consider including disclaimers and warnings to users. If let's say you put up a chatbot on your website, you might want to say, oh, maybe you can't totally rely on this because it's AI powered. But then we'll see in an example to follow whether warnings and disclaimers are really effective in limiting your liability. And finally, keeping abreast of the laws. It's important because this is a very fast developing area with many countries putting in place or considering AI specific laws. So we'll look at some of these laws that are in place in the final section. So this is an example of the effectiveness, to show the effectiveness of any disclaimers about the performance of the AI system. In this case, this person called Mark Waters, he sued OpenAI for defamation on the basis that ChatGPT had made certain false claims that he had embezzled money from a guns organization. So Mark said, oh, well, look, this is like rubbish because I was never I didn't take money and I was never part of that organization. OpenAI argued that it's not liable because it had warned users that ChatGPT could produce inaccurate information, and also that ChatGPT's terms of use state that users must verify and take ultimate responsibility for the content they decide to publish. So based on this, ChatGPT filed a motion to dismiss the claim. So that's basically telling the court that, oh, this is a rubbish claim without any merit, so you shouldn't even bother to hear it. But the US court, they denied the motion, so the matter will now go to full trial, right? So it'll be fully considered by the court. So the conclusion is that it remains to be seen how effective or ineffective such disclaimers are. The other point is that whilst such disclaimers and terms of use may limit the developers or deployers' liability to a user of an AI system, they could be of limited effectiveness when it comes to claims by third parties who receive the outputs from the user, right? So, for example, in this case, Mark Waters was not the user of the AI of ChatGPT. And in fact, he had received the outputs from a third party, from another person. So even if the court were to find that these limitations and terms are effective to limit liability as against the user, they may not be effective against Mark Waters. Okay, now we move on to the third topic, which is copyright protection for AI-generated works. So the issue of whether AI-generated works can be copyright protected has been hotly debated. If you've been following like the news, we may have seen some of these discussions. And one of the first cases which brought the concerns to light is this how the US Copyright Office dealt with this graphic novel entitled Zaria of the Dawn. So the Copyright Office first granted copyright registration for the images in the novel, but then later revoked that registration. Right? This is because the artist had indicated in her application for registration that the images had been generated by a AI image generator, that's Midjourney. So the Copyright Office denied registration on the basis that, oh, I cannot grant copyright protection to AI generated output, right? This is despite the author's arguments that, oh, I had put in tens and thousands of prompts to refine the images before they were finally published in my novel. So what is the issue? Or what's the issue with granting copyright protection to AI generated works? Well, when we look at the requirements for copyright protection, there are two key requirements. One is that the work must be original, in the sense of not being copied. And the second is that the work must have been created by human authors. So for AI-generated works, it is thought that there is no human author because all the creative input came from a machine. Right. So if you recall this case of the monkey selfie, where like the monkey apparently like some photographer set up like a camera in the forest and monkey came along, took its own selfie, and there was a dispute as to whether this is copyright protected and so who owned the copyright, right? So it's the same issues this time, except that the monkey is AI. So this requirement of human authorship is not unique to the US. It also applies in Singapore and other Commonwealth jurisdictions, like for example, Australia. So far, only China has taken a different approach, with the Chinese courts having recognized the AI-generated image as copyright protected. It's not because in China there's no requirement for human authorship. It's more because the Chinese courts were more prepared to recognize that even with the AI generated work, there could have been human creative input, for example, by way of refining the input prompts. So where we are now is that, long and short of it is that in Singapore, there's no copyright protection for purely AI generated works, though the law may change down the road. So then what is like if you are using AI to create images or material, what are some of the things that you can do, right? First is that so one practical consequence is that you will need to be circumspect about providing warranties that any generated material are original or protected by copyright. So this will more often impact, let's say, the content creation companies or like people who design websites for customers. And then another practical consequence is that there may be difficulties taking enforcement action if third parties copy that AI output, because the first step in establishing copyright infringement is that there'll be a need to prove that the work was protected by copyright in the first place. The second question is whether there is any way to increase the chances of protection, right? I guess one way is to ensure that you don't just put in one prompt and get one output, but use iterative prompts to refine the output, so there's more of an argument that there is human creative input to any AI produced picture or text. Of course, also if there are like manual adjustments made to the final output before that's published, then that would be ideal. So the final question is, if AI generated works can be copyright protected, who will own the copyright? So like we said, there can be no copyright protection at this point, but it's worthwhile trying to put in maybe some language in your contracts to say who will own the copyright in case there is copyright protection, because we don't know whether new legislation will be put in place down the road. Okay, then finally, the final section on legislative developments, just a very quick word on it. Basically, China and Europe are leading the way when it comes to AI-specific legislation. China has a number of these interim measures and things like that, but it's also looking to put in place a national AI law. And then we have EU. The EU AI Act came into effect in August this year, and it is the EU approach and the outcomes there that many countries are looking to for guidance in shaping their own AI legislation. So briefly, the EU AI Act adopts a risk-based approach with AI systems that are classified as high risk, subject to more stringent regulation. So these would be systems that impact on fundamental human rights, such as in the areas of recruitment, public benefits, law enforcement, as well as systems with safety implications, such as like AI-driven medical devices. So these are classified as high risk. Whereas most other systems that are currently available are classified as low risk and subject to minimal requirements. For example, transparency obligations. You have to tell customers when you're using these things that they're dealing with an AI rather than a human, right? Then you have this like pie chart at the corner. So it's just there to show that in the absence of specific AI laws, for example in Singapore, it does not mean that the space is unregulated, as there are existing laws in place still govern various aspects of what is done with AI tools. So like we said, Singapore, there are no AI specific laws. The regulators are adopting a wait and see approach to see what happens in other jurisdictions first before they put into place these laws. But what we have is a series of non-binding guidance, the Model AI Governance Framework that sets out like 9 dimensions to foster a trusted AI ecosystem. And then there are guidance that have been released by various like for example the Personal Data Protection Commission, MOH, MAS, to govern use of AI in certain specific fields. So again, this is very much a watch the space because we expect that AI specific laws will come into place sometime in the future. We just don't know when. Okay, I've come to the end of my presentation. I think let's look at Q&A. Okay, I don't see any questions in the Q&A box.
Yeah, there's no questions right now. So
Yeah.
once again, thank you so much for Pimping for your insights. I think I'm very curious also to hear like where the laws will lead in terms of all the cases that have come up, right? Whether it's the last one of the monkey one, that was cute. I mean that was an example. But also
Yeah.
the airplane one. So interesting cases that we want to, and which you said, right? The it's not conclusive yet, right? Although the ChatGPT has filed to dismiss various cases, but the law is looking to see where the legal liabilities lie still. Yeah.
Right.
Maybe.
I think I see two questions in the
Oh,
Q&A,
actually,
so
yes.
maybe we can quickly address those. So the first is, if we train our copywriting with our data, could we claim the IP is ours? So I think this one, there is a difference between, if you recall that diagram, right? If you put in your data as part of the training data, right? Then your question is whether then whatever you can claim that whatever output comes out from the AI system is your copyrighted works. The answer is that well, that's not an automatic conclusion, because even if so yeah, it's really down to whether in the contract between you and the AI developer, what it states about the ownership and rights to use the output, right? Because even if you were to input your own training data to train the model for the AI system, it doesn't mean that the entire output is based on your training data. It could be based on other training data. But in any case, that is not the legal question when determining the ownership of the IP in the outputs. The second question is, can you use AI generated images for marketing materials? Well, of course you can. The issue is really whether uh, there is any issue with copyright infringement. So just now we briefly mentioned that there could be infringement if copyrighted works are included in AI training, is used for AI training without the copyright authors, right, owner's permission. Uh, and many of these like unauthorized instances of use are detected when uh, the AI inadvertently includes some of the training data in its output. So that's apparently very common. So you can use AI outputs for whatever purposes, but just be aware that if there is unauthorized use of other people's copyrighted works for training, or or for like as your inputs, then that an issue might arise. Okay, one more question. If I'm an AI vendor and my client wants Gen AI agent to reply text messages and emails of their customers automatically without human to approve every first draft, what kind of contract should we have between vendor and client? What are the key things that should be inside to protect liability? So I think this is the example that we saw of Air Canada's chatbot, where the chatbot like gave wrong answers. Then then who is to be liable? Is it the customer, or is it the AI vendor? And I think it's important for the contract to properly spell out what to try to it's not a one size fits all like kind of answer or liability, because if the wrong answer were provided by the customer in the first place. So for example, if they provided you with, okay, this is the list of FAQs and the standard answers that should be used to train your chatbot, and the error was contained in whatever they gave you in the first place, then surely you will tell your client that, hey, you must be responsible for if the error arose right? On the other hand, if it is due to whatever failing in the way you wrote the code, then it's likely that it's going to be the vendor that is liable. So again, no like straightforward answer. I think you have to think through the possible how the errors could possibly have arisen and try to apportion liability appropriately in every circumstance. Further question, if LLM model is provided by third-party vendor, but the data used for training belongs to me, but when I use the model, the generator output from the model seems not reflecting the reality of my data, or even come out from nowhere. Does this mean vendor shall bear full responsibility for this issue? Yeah, so I don't think it's so much of whether the data. So you're saying that the model, it's really the output does not seem to link to whatever training data that you have put in, right? I think this could be because you have given the vendor some training data, but there would be other training data in the background that could have been used to train the model. So the output could have reflected not just your training data, but the entire corpus of other training data, right? So, but it's only, yeah, so I think you have to sort out exactly, I mean, one solution to this might be to tell the vendor to limit whatever the training data is. If you want the output to correlate very closely to your specific training data, then maybe take out all the other stuff and just have the output, just have your stuff as the input. But otherwise, then it certainly sounds like an issue with how the software is written. Next question, will you be able to share the presentation with all of us? Yes, I think SG Tech, if you reach out to SG Tech for a copy of the presentation, it can be shared, right? So given the fact that AI is adaptive, also even though liabilities among parties involved are defined, providers may be able to rely on adaptive AI to get away from liabilities. Yes, potentially so, because so that's one of the unclear areas, like a loophole that the provider might potentially exploit, right? So unlike traditional software where if something goes wrong, you can just look through the code and say, this is where it went wrong in the code, and this is why I'm getting my rubbish output. That's not possible to do for generative AI, right? Especially if it's adaptive. So yeah, so it's one of the areas that is not fully clear how liability is to be apportioned, because that's one of the times when AI seems to be the one which is coming up with its own stuff. Then really how how are you going to decide who is liable? I think the some of the what's that? Some of the recommendations in this regard is when you do your like acceptance testing, right? When designing the testing criteria, you have to take into account this thing about the probabilistic nature of the outputs of AI. That means it cannot be like for traditional AI where one input always gives you the same output, right? It can be that one input will give you a variety of various outputs that all could be acceptable. And then the other thing is that to keep very careful records of what outputs you get from certain inputs during your acceptance testing phase, because then that could help you with determining when something like that goes wrong. Whether try to pinpoint whether it's something wrong with the code or something that happened like yeah that shouldn't have happened. Next question, will the liability be ours if AI, for example Mid-Journey, generates output based on copyrighted material and we use this for marketing? So that's the issue with what I said about when you use, for example, ChatGPT. So ChatGPT is not an image generation thing, right? It's a LLM. But then it's the same concept that if the provider of the AI tool is going to tell you that, oh, you use at your own risk and my liability is capped at $100. If you are sued for copyright infringement for publishing that material, then the most that if you try to look back to the AI provider like ChatGPT or Journey to say you have to compensate me for whatever I have to compensate the copyright owner, they'll just point back to the contract and tell you that, oh, I'm not liable or my liability is capped at $100. So now I give you $100 and that's it. So that's why it's very important to make sure that if you want the developer to hold more of that responsibility, then it has to be properly, that liability has to be apportioned under the contract appropriately. Next question, what responsibilities do companies hold when working with third-party AI vendors, and how can they safeguard themselves from potential liabilities related to AI-generated content? What responsibilities? I don't really. How can they safeguard themselves? I guess again it's back to the question of making sure that you want to make sure that whatever warranties and indemnities that the developer ought to provide should be spelled out in the contract. So it's not only for AI. Okay, so for AI generated content specifically, the major risk will be with IP infringement, right? So you might want to say something like, oh, if there is infringing output coming out and it is due to the use of copyrighted works in the training data without permission, right, then the vendor ought to be liable. Yeah, so the way to safeguard yourself is really by making sure that the contractual terms properly spell out whatever warranties and indemnities they ought to give you. And the same will apply to, I guess, any other systems. I mean, if you get your vendor to create systems for you to like generate data that will be used for decision making, then that would be when you will put in terms to say, okay, vendor, you should be liable for making sure that the data that you put in is representative, free of bias, and robust. And so, yeah, so again, there are certain known pitfalls and difficulties with using AI. And if you already expect that there will be these things, then the best thing is to try to address these under the contract. Okay, next question. If synthetic data generated from our IP data is used, what other potential liability issues could arise beyond data bias? Uh, sorry, what I don't really understand what IP data is. Uh, yeah, maybe if you could, this comes from E. Lindy. If you could clarify, maybe retype the question.
Let me try to let Lin
Yeah.
Lin to speak just 1 second. Hi, Lin. I've allowed you to speak. We can unmute your microphone to elaborate. There'll probably be the last question of the day as we come to a close or 11:30. Elin, are you with us? Oh, yeah, she's.
Yeah, sure. Maybe I'll quickly address the next one. Are there suitable contract templates that we can refer to that try to clarify liability in different scenarios? Yeah, I think if you do a Google search, there are like templates, contract templates that have been published by various organizations. Not so much like Singapore sources lah, but I think the templates coming out of like Europe, especially the UK, would be the most suitable. Like be very careful if we use like stuff coming out from the US because US laws are quite different from ours, especially when it comes to like IP law. Some of the terminology that you use is different. Elaine says in terms of training data, apart from real life data nowadays, there are synthetic data generated by AI being used to produce output. As such, it will make responsibility split even more complicated. Yeah, correct. So, yeah, I think totally agree. Okay, I think that's all.
Yeah. So I'm sorry, Elin.
So I think that the clarification was the last point from Elaine.
Oh, okay.
Yeah.
Okay.
Like she's explaining what synthetic data means.
I
But
see.
yeah, and I'm afraid I don't really have any do we foresee any if you train data with synthetic data, do you foresee any liability issues? Arising specifically from synthetic data, I don't see any specific issues arising from that. I think it's more of like the person who comes up with the data, right? So like training data can come from developer, can come from customer, but then if it's training data that comes from developer, you can try to address that in the contract to say whatever you give me, you just make sure that it's authorized, it is like foolproof, free of bias and all that. But if it's stuff that if you as the customer is feeding into the system, then any problems arising from that, then you cannot point fingers at the developer. So whether it be like natural data or synthetic data, I think the same principle will apply. I'm not aware of any specific issues with synthetic data, except that maybe it might be less robust than normal data in certain circumstances.
Okay, with that, Ping Ping, we just really want to say thank you so much for really answering all the questions and all our attendees and our guests today. Thank you for the excellent questions. I think you probably have a lot more questions coming that you may have. If they do have more questions, how can they reach you, Ping Ping?
I suppose I think they can just Google my name. And yeah, my email address is found on my profile on Bird Bird's website. Or else, I think for those of you who want a copy of the slides, I think you can reach out to SG Tech and they will share. And my contact details are found on the last slide.
Excellent, excellent. Well, once again, thank you so much, Ping Ping, and all the audience for this session. Look forward for our and also Christian has shared the email address in the chat. We'll be sending the slides to you after as well. Request for that. Once again, thank you so much. And if you have any further questions, you can go straight to Ping Ping at Bird ATMD.
Thank you all.
Do you have any
Bye.
last words? Thank you. Bye.